Mr. Chairman.
The Honourable Dr Nick Smith.
Mr. Chairman, because the SOP deals with this issue of retentions that was not in the construction contracts bill that went off to Select Committee, it's reasonable just to take a moment of the House's time to explain both the history of these new provisions and to answer some of the questions that members have raised. I think it's firstly important to put on the record that the genesis of the problems that have occurred in ill-disciplined construction contracts actually goes back to significant changes that were made in 1988 by the Labor government in repealing, as one member mentioned, the Liens Act. And the Liens Act was a very powerful tool by which a subcontractor or contractor on a building site could register a liens against the title and so protect the considerable investment that that builder or subby may have in a particular building project. After the Liens Act was repealed in the sort of height of Rogernomics, an increasing number of incidents occurred in the construction industry that I think made New Zealand and the Parliament feel uncomfortable. I actually introduced a private members bill in opposition in 2001 to try and get action in the space. The Construction Contract Act, I commend the work at the time that was done by Lala Hari in bringing that act into force. And today we're dealing with this quite specific issue of how retentions can be dealt fairly. And I think David Cunliffe put his finger on the pulse accurately, and that is, this is an issue about where the risk is carried. There are no free lunches here. No matter where Parliament chooses to impose the risk, there is a cost. The true question, Mr. Chairman, for the Parliament is to try and ensure our commercial law around construction ensures that the risk rests with the party that is best able to manage that risk. That, in my view, is where the public interest in what this Parliament should be focused on. And I do agree with those members that have said that in the current environment, where a main contractor is often in the position to have the most information about the bankability of the client, whether he's going to pay his bills or such things, is not necessarily the party that carries the risk. And we've seen a number of high-profile failures where good, hard-working, small New Zealand businesses have lost out. Now, what we've attempted to do in SOP number 106 is provide a practical regime that will address that issue, but also being cautious of either wasting money or introducing compliance costs that over-egg the problem and end up adding more cost than what we save. So let me go through firstly the questions that Julianne Genter asked, which is actually one of the most beneficial elements of the changes in these retention provisions. And it is this. At the moment, if a large construction company goes broke and there are retentions owning, they are unsecured creditors and are at the back of the queue. The key change that is made in this bill is that those funds are deemed to be held in trust, and that means that those funds are firstly paid out of the circumstance. And if we all take the high-profile example of Mainzeal, where there was about $20 million worth of retentions, all of those subbies would have got paid ahead of either the secured creditors like the banks or ahead of things such as the taxes, the wages, and the other things that normally occur where there is a liquidation of a company. So that's a big gain. The second provision is then, how do we ensure that these monies are firstly transparently reported and also that there isn't a waste of money. And so what we have done with these provisions, starting in section 18A, is setting out those trust obligations that rest with the party holding the retentions, setting out that there will be a default rate of interest set by regulation in the event that they are not paid on time, setting out when that trust obligation concludes, i.e. that they're either paid out to the subby or the work that's substandard is fixed or some other legal means. And it does enable Mr. Chairman. I'm sorry, I'm a couple of seconds early. It also enables the person, Mr.
The
Chairman,
Honourable Dr Nick Smith.
it also enables the party who holds those trust funds not just to have the monies sitting loose, not having to have a separate lawyer's bank account. It is true that in some jurisdictions they require that. In my view, that would be overstretched. That would make the compliance costs excessive. We also need to be honest about what these provisions will do in terms of the bankability of development and construction projects. There is no free lunch in improving the security of the payments for the subcontractors. It does mean there are projects that may have gone ahead and would have been bankable that now will not be, because the trust imposed by this law means that there will be banks and other parties that are more cautious about a particular construction project proceeding. It is also true that it significantly changes the cash flow position for a number of projects, and that is why the provisions in the SOP give a reasonable time of transition for the construction industry over to these new arrangements. The last point I'd make is I have had contact from a number of people in the construction industry who would prefer to have alternative arrangements that are common in the United States, bond arrangements and those sorts of things. I want to emphasise that no matter what we have in our construction law, this is in the area of contract, and if people want to enter into arrangements for performance bonds, they are free to do so. And equally so, no amount of good construction law will ever save somebody from contracting with parties that are not bankable, and parties entering into construction contracts do still need to show caution about who they're doing business with, that they are bankable, and showing the normal due diligence, because this Parliament would be misleading to subbies if they said any law is going to provide them with absolute protection of payment. Mr. Speaker, in my view, these are pragmatic provisions. I do note that some members have claimed that their SOP was tabled first prior to the government's, and I would simply point out actually the government noted, in fact, last July that we intended to make these changes and to provide for increased protection for these retention payments, because we do believe it will provide for a more disciplined and more sensible way in which retentions are managed in the construction industry.